it is not useful to have something like this reviewed by somebody who doesn't understand software, how it's built, because they will not detect half of the issues and the critical issues of this. So for something like this, you really want somebody ideally with an engineering background who became a lawyer, or the other way around, because they are so technical, and it's the smallest thing that can trip you up and make your insurance policy completely uninteresting and unuseful.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney and tech founder Martin Clausen digs into a SaaS Escrow Agreement from Escrow London Limited. This document has a particular purpose, giving a business that's relied on a technology the ability to continue using it even if the developer closes up shop. But while escrow agreements are a common form of insurance, translating them to the modern world can be a clumsy undertaking. Martin explains how lawyers can mess up that transition and why they should defer to drafters that understand the context. There's a lot to learn here about bringing old concepts into the modern world. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. The point in this show is to beat up contracts. I hang out with smart friends like my friend Martin over here, and we make fun of things and we pull things out you should pay attention to and maybe help you write a little better. Martin, how are you doing today?
I'm good, thank you. How are you?
I'm okay. It's okay. Everything's just okay, man. I had a day. Yesterday was Monday. Anyway, I don't know why Mondays still hurt my feelings because there's no such thing as a weekend now. But
Mondays are offensive.
It still bugged me. They should be unconstitutional. Yes. So, guys, what we're doing today is talking about a specific document. Let me share my screen with you real quick. It is actually found on Law Insider. It is a single beneficiary software escrow agreement. This one comes from escrowlondon.co.uk, and you can see lots of links in here. Basically, what that means on Law Insider is that you can find similar language to these different clauses elsewhere. But before we dig into it, Martin, let me ask you real quick to tell me, what is this document? When will people see it? Why do they care?
Well, so the last maybe 5-10 years, the way of consuming software has changed drastically for many people and many organizations. So whereas in the past, software was something you bought maybe in a box and installed on a server in your own data center, or maybe a service where a data center that you had access to locally, software today is for many people something you just access online as a software as a service or web application or whatever you want to call it. Now, this agreement has been created as a sort of an extension of agreements that existed also when software was something you just bought in a box and installed. Because people back then were already thinking, what if this software vendor goes away one day? What if they go bankrupt? What if their HQ burns to a cinder or whatever? How do I keep this software maintained and in working order as a company when I'm now relying so heavily on this piece of software? So people came up with the idea of a software escrow agreement whereby the source code and materials that were necessary to maintain and keep the software operating were deposited at a third party, trusted third party, that would then, upon one of these events happening that would make it infeasible for the vendor to continue supporting the software, would release the source code and other materials to the licensee, and they could then proceed to either maintain and support the software themselves or maybe hand it over to a third party. Same problem happens and occurs, the same theoretical problem at least presents itself with software as a service, but with a few added complications, because now the software is also now hosted typically in a third-party data center, Amazon Web Services, Google's cloud, whatever, and it becomes important to maybe keep that infrastructure up and running if the vendor goes away. So we'll see that topic is sort of also addressed. We won't have time to go into the details of that, but that topic is also addressed here. So that hopefully sort of sums up the rationale, the need for the raison d'etre for this type of agreement.
So talking to me like I'm an idiot, you got a buyer, a seller, a dude in the middle, or a middle woman, whatever middle gender neutral term you want to use. You got somebody in the middle who's making sure you can get access to the source code if you've relied on this thing for a while. But as you said, it's weird because now we got somebody else involved, this hosting company. So what we'll do is go through this section by section. You are not an idiot, however, Martin. So before we get into this, tell me really briefly about your background. What brings you to this kind of document? Do you see these a lot in your practice?
So not these days, because these days I do legal tech software actually, but I spent the majority of my career in IT law, working with contracts both on the seller and buyer side, and I've seen this type of agreement from both sides, all the way from way back when they were used for just old school software to software as a service, and it's an interesting type of agreement because details often matter in agreements, but in these types of agreements, there's a lot of practical things that needs to be in place for this agreement to be useful at all, because the whole idea of taking over somebody else's software and maintaining it either yourself or having a third party is very hard to get right in the first place. But if you're up against something when you're not getting access to the right bits and pieces at the right time and so on, it's going to be impossible, and you are going to have been paying for something that turns out in the end to be useless. So if you decide to put one of these things in place, you have to invest the time to get it right, and getting it right in this case means getting everything right. Otherwise, it will potentially be worthless.
Yeah, let's get through it, because it's such an interesting context, taking an old concept and trying to wrap language around it that makes it, apply to the now.
Yeah.
So we're going to start at the beginning, as lawyers do, and go to the definitions. We've got a fairly long section with a bunch of words and quotes. They've set it out. They put it at the beginning. We've talked about this in other episodes. Talk to me about some of the terms that are in here that are raising red flags for you.
Yeah. Well, the first one that I've highlighted in the text is the word deployed in the definition of access credentials. It's just to highlight the fact that there is actually this is not about software that is deployed on a server. This virtual server, it does exist in the agreement and it makes sense, but deployment usually means that something is deployed where you can then access it and use it. In this case, deployed means something else, and I just wanted to highlight that you shouldn't be confused by that. Deployed in this case just means there's a copy of the software on the server. It doesn't mean you can use it. It's just a place where it is at. Mm-hmm. Next thing that I highlighted is the word source codes in the deposit materials. I highlighted that mostly to make fun of it, because it's clear that this agreement is written by somebody who doesn't know a lot about software, because if you use the word codes instead of source code, it's because you think that source codes are somehow cryptographic codes or something that will unlock something, which is, of course, not the case. And it should, just as a general thing, make you raise your eyebrows and be aware that some of the technical aspects of this agreement might not be in order, because it's been written by somebody at some point who didn't even understand the fundamental terms of what they were dealing with, namely source code.
I'm totally nodding my head right now as if I know what you're saying, because I saw War Games with Matthew Broderick 20 years ago. But I'm with you. I should not write these things.
You should, if you trip over something like this, you should sort of, maybe there's other things that they haven't got right that's really important to me. The next thing is the word build. Again, it's a technical thing, but this is going to be highly technical, and that is why you want somebody reviewing these types of agreements, a lawyer who actually understands software and understands how software is built, how it is deployed, how it is operated. Because the word that they're using here is they're saying that it means that the proprietary technology required to build the product. Now, build is a specific step in the process of making software accessible to an end user. But it's not everything. There's a lot more to something than just building it. You need to deploy it, as we talked about, which means copying the right bits to the right parts of the server, of the infrastructure. You need to monitor it afterwards so you're sure that it's behaving as you want, that it's not running out of memory or using too much bandwidth and so on and so forth. It's just to say that if you go into any one of these agreements, and this one in particular, you want to make sure that the steps that you are going to need down the road are actually covered by this. And it's not covered just by using the word build. It's probably going to take us too far to come up with an alternative definition, but it's just something to be aware of. Moving on, file integrity test definition. It ends by the word viruses, which is kind of saying, okay, you need to make sure that we have the material that we promised, but you also need to make sure that it's free of viruses. And it's oddly arbitrary word in a world where there are a lot of other things that could be wrong with the software besides being virus infected. It could be other types of malware. It could have booby traps. It could have like encryption that all of a sudden spreads to the rest of some key part of the software that makes it unusable. So you probably want to modify that definition too to make sure it covers all the adverse effects that could apply to the software. Next thing here is a SaaS, software as a service specific thing, the hosting access credentials. I've highlighted billing and payment section of the third-party hosting and application vendors. The reason why you want access to this at all is because you want to be able to pay this hosting vendor to keep the software as a service operating.
Going, yeah.
The idea here is that I'm a software vendor. I provide you with a software as a service solution, but I'm probably using a third party like Amazon Web Services or something to actually serve the software. Now, one thing that happens if I go bankrupt and the material is released to me, released to the customer, that is that the bills are going to be stopped. The AVS bills are not going to be paid anymore. And you want access to be able to pay those bills so you can keep the software operating. You want to consider whether or not those two sections actually cover what you want. That's all I'm saying with this. It might not. It might be that you need access to the monitoring section of the website, whatever. Just think about it in practical terms and in the light of the specific software that you're buying. SaaS agreement definition. I've highlighted the computer code as part of the definition of source code, which is oddly now here on the same line of this agreement. I don't really know why, but just to say that there might be other things that you want to include in the source code definition. There might be configuration files that a person would not say actually qualifies as computer code because it's configuration. There might be data. There might be other types of information that you would want included in the definition. All depends on the product. It might be that computer code is fine. It might also be that it's actually not fine and you want something else included in that definition. So you can already tell by now that it's really nitty-gritty stuff that we're dealing with here. It's not, principled high-level stuff. But if you fail on any of these things, you risk invalidating the purpose of this agreement entirety, and it's just not worth dealing with it then. It's not worth the hassle of entering into it.
Well, and you've almost got like 2 degrees removed from the lawyer in the sense that, it was already complicated when it was the 90s and we were buying software in boxes, and now we're trying to extend this language even further, which that lawyer might not understand. And so that's really helpful.
Exactly.
I'm looking now, this is an escrow agreement, so I'm thinking about the deposit of deposit materials, as they call it, in Section 2. Take me through some of the language in that section that stands out to you.
Section 2.2, I should say that Section 2.1 is the sort of primary thing. It's you have to start by depositing the source code or the deposit materials, as it's called, by electronic upload. That's a duty of the software vendor. They have to upload the source code to a server, and now it's in the care of Escrow London in this case. So that's, of course, fine that we start out on the day that they enter into this agreement. But, of course, software changes, and you don't want the version that was current of whatever product like 2 years ago when something happens. You want the latest and greatest. So that's what 2.2 deals with. But as opposed to the first section, it actually doesn't even give a deadline as to when new versions needs to be uploaded. So I could ostensibly delay the upload by 6 months, by 8 months, by 9 months, and then when a release event happens, when I crack open the server and see what I've got, it's something that's 9 months old. Right? That's not, and I don't understand why you would take care to include a deadline 20 days, 20 business days in Section 2.1, and then not do it for new releases of the product.
Yeah, it just says following a new release, which
exactly.
could be.
And it seems just sloppy. Yeah. I don't know. I have no idea why they would do it. We're getting back to the really technical stuff here. 253. It sort of specifies what information needs to be available in this deposit. And they're saying here detailed documentation, detailing the operating system, hardware, third-party software, and software tools required for recompiling the product. Also, an oddly specific term, because compilation is part of building a product. You're taking source code and turning it into something the computer understands through a compilation process. That's a very rough, description of what happens that no computer science person would ever forgive me for using, but that's essentially it. The thing is that there are other ways of building things. Not all software is compiled, some is interpreted, and so on. So you need to be specific on whether or not this actually covers your documentation needs for this particular package. And to evaluate that, you need to understand the details of this software. Also, it wisely, and which is kind of a plus, I would say, in 254 says that it's not enough that you give me documentation. I need to know who did this, because sometimes there's tacit knowledge that I can only get at by knowing who's actually who built this thing. Mm-hmm. I want to be able to reach out to these people. You don't see that in all escrow agreements. Somebody has wisely included it here, but they are only sort of addressing people who know the product development and structure. I'm not sure that I feel comfortable with that. I actually might also want the people who know how to test the software. I might want specific individuals that know something about, the dark corners of something. There might be a specific algorithm somewhere that only one person or two persons know something about. That's key to keeping this thing alive. You might want to consider inquiring into that and getting the right people either by name or by other roles than people who know about development structure. As you can tell, again, very practical, low-level stuff. Again, if you don't get it right, you might not. This thing might not save you as you were hoping. Okay. There's two materiality requirements in 262 and 263. They should just be deleted. They make no sense in the context of what they're talking about. They're talking about material changes to names and contact details. There are, as far as I can tell, no such thing as an immaterial change to somebody's contact details. I mean, as we spoke about just before we went on here, if you change one digit of somebody's phone number, it's still not going to work for you, right? So what is this material thing? It doesn't make sense. Again, an oddly specific thing that some technical person that wasn't the person who used the word source codes put in here in 2.7. Git repository. Okay, this is it's a very specific piece of software that's used to archive and version control your source code. But it's one version control system among many software version control systems. And I don't understand how somebody put in here a specific name of a product. It could be that this vendor uses a different product, that then this doesn't apply. So I don't know.
Moving to 2.9, this one's a section that fascinates me, and you sort of see this coming up through this document. They're disclaiming a warranty here of things that seem like exactly why you're purchasing this relationship in the first place. Talk to me about the language of this disclaiming a warranty that's in 2.9.
Yeah, it's just overly broad. I mean, it's okay that they are not, as an escrow provider, liable for the internet connection coming into them and maybe corrupting something. But if you go to it with a fine-tooth comb, we don't have the time to pick it apart. Just be aware of it. It's overly broad, and it actually excludes some things that you want them exactly to be liable for. So please be aware, and you'll see that in many escrow agreements, the escrow provider trying to be completely outside reach from a liability point of view. 211, it's what is going to be deposited. It says here it warrants, represents that the deposit materials are sufficient to permit the manufacturer, use, and support. Again, manufacturer it sounds like it's software is something produced in a tin can factory, right?
Okay.
It's again somebody who doesn't know the specifics of how software is built. That's for sure. Then I'm being kind. But sufficient is a problematic word here because I don't want what's sufficient. I want everything. I want it because sufficient means that it's theoretically possible for me to build something. That's not what I want. I want exactly what all the niceties, all the tools, all the bells and whistles that they use to build it for themselves. I want all that. I don't just want what's sufficient. So sufficient is actually a truly dangerous word in this definition.
Well, yeah, because they're assuming, am I right, that in this kind of agreement, they're assuming that plausibly you company owner, are going to take this information at your expense, go build something. I mean, if they give you just, sufficient zeros and ones, it doesn't necessarily, it could make it really hard and business-wise impossible for you to maintain.
And it's extremely hard in the first place, even provided with all the information, all the access information, everything. It's still, some people consider it more or less theoretical that you could even do it, that you could hand over a moderately complicated software package in source code form, and then either for the customer or some even knowledgeable third party could take it over in a timely fashion. So some people just avoid escrow agreements altogether for that reason. But some people think that it's possible, and they evaluate the circumstances and say, well, it is possible. But it's certainly not going to be possible just with the sufficient materials. You are going to be wanting everything because you're starting from scratch. You or somebody else on your behalf is going to be starting from scratch. And that's a challenging proposition in itself, right? So
anything else in this deposit area that's standing out to you?
Yeah, so we're 214. This is just a thing to be conscious of. When people build software, they sometimes rely on software they license from third parties. This agreement deals with that, and it includes the source code for those third-party products. But it also says that when it's released, you have to go yourself to these third parties and ensure that you have a license to use it. You don't know what that license is going to cost, or whether that third party is going to be very cooperative in granting you that license. That's a potential hold-up scenario that if I ever saw one. So you probably want to clarify this, maybe get some specific options to get those licenses with a price, with a deadline, all of that. So you're sure that you actually know the terms in their entirety for getting access to this stuff, right? So, yeah. And lastly, in 224, Escrow London may assign, subgrant, transfer, blah, 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 all of its obligations. Now, when you pick an escrow vendor, you probably pick them because of their reliability, because of their track record, because they're dead solid, because they have excellent infrastructure that will protect the source code against all eventualities and so on. Is it really reasonable for somebody like that just to be able to assign this to their brother who runs the kebab shop down the corner? I don't think that it is. You're picking this entity for a specific purpose with a view to their skill and their track record. So I would just, obliterate a clause like that, or I would substitute it for something with a lot more assurances as to the quality and so on of the substitute escrow vendor.
Right, which is as simple as if an assignment is proposed, give me some ability to refuse that or whatever, or some
exactly, or objectively prove to me that they are at least as good as we are. Right. Something like that.
Yeah. No, that's really helpful. And once the deposit is made and they're holding this stuff, I'm looking down at 4 where they talk about default. And if I'm understanding correctly, they're not talking about default of the original agreement or whatever. They're talking about what are the triggers that lead to the release of the information that was deposited into.
That is exactly what they're talking about. And these are events of default, namely where the software vendor fails to make good on their promises under the SaaS agreement, right? So the first one is here that they fail to support the deposit materials in accordance with the SaaS agreement. Technical point here, actually they're not supporting the deposit materials, they're supporting the SaaS application to you. So this is just on its face wrong, the way this is described. Secondly, you want to make sure that the word support here is adequate and that it matches some concept that you can find in the SaaS agreement. So they're probably doing something else beyond just supporting the software. They're operating it, yada, yada, yada. So you want to match those terms up to the service that you are being provided. And in 415, it just talks about that the depositor ceases active operations of a business and discontinues the licensing or maintenance of the deposit materials in material breach of the SaaS agreement. Again, I would consider whether or not material is relevant here, because if they breach it, and that should be enough to given that the qualifications here are already cease active operation of its business or discontinues the license. I mean, I don't see how a materiality requirement actually would operate meaningfully here. So I would at least challenge it, and I would make sure that I get this to trigger when the things happen that I want.
Got it. So moving down the contract. So now we've deposited the stuff. We've had a triggering event. Stuff has to be released. So we're down in 5, release of deposit materials. What's standing out here for you?
Yeah, we have this very odd concept in 5.3 of contrary instructions. So this is like the vendor's ability to say, okay, I realize I've been notified by Escrow London that you, customer, are claiming that that a release event happened. I disagree, and now I'm providing you contrary instructions not to release this software to the customer who paid for this agreement and everything. And then it triggers a dispute resolution mechanism that is not nearly as quick as it needs to be, considering what we're talking about. The dispute resolution mechanism is found in section 6, further down the document.
Right. The whole point is that
the whole point is that
business.
Exactly.
Yeah.
The point is also that if I'm making this claim and I'm turned out not to be right, I will be paying substantial damages to the software vendor at a later stage. But it cannot be that a software vendor in a potentially and likely in a very fragile state, they are maybe fighting for their business on the verge of bankruptcy or whatever, gets to make a contrary instruction, as this thing highlights. I would just wipe this thing out. I think I have seen it before, but I still consider it very unusual in this context, I would say.
What else in 5?
So we have in 5.6 we have the use. We have the terminology or the word use the deposit materials. So this is talking about what are my rights in relations to this deposit materials that I'm now being handed. I get the right to, I have a worldwide royalty-free, irrevocable, perpetual, freely sub-licensable, non-exclusive license to use the deposit materials. I mean, that looks on its face pretty okay, but since we are talking about potentially copyrighted material, use is actually not one of the exclusive copyright rights. One of the rights that you get to maintain exclusively for you if you have copyright in something is the right to, oddly enough, copy stuff. Use I can't use copyright to prevent somebody from using something that I have copyright to. I can prevent them from copying something. I can prevent them from displaying something. Viewers should look up the definition of what copyright exclusive rights are. And they're a little bit different depending on jurisdictions and so on. But use is not one of them. Right. So it's very odd that what they're granting here is the right to use, because it's not an exclusive right that I have via my copyright. So look into that. Make sure that the license grant is actually fit for purpose.
Well, and in 5.7, they start talking about the financial event of default. It's defined up in 4.2. They talk about the depositor's failure to pay the financial invoices of any third-party vendors in accordance with their agreement. So what's the specific trigger under that particular reason for releasing the information?
So this is prior to we should probably look at the middle sentence here. Prior to making any payments to a third-party vendor on behalf of the depositor, Escrow London should be entitled to receive full payment of outstanding invoices from the beneficiary that declared a financial event of default. So if I call this financial event of default, I need to pay up anything that is owed already by the depositor. You should just, it's probably not something you can change due to the circumstances, but you just be aware that there's a potential massive bill to be paid up front before anything happens here. And the thing is that you might be paying on behalf of other customers too, because software as a service has the nature that it's hosted on a piece of infrastructure somewhere for the benefit of all the customers of this vendor, not just you. And the bill is proportional to the fact that there's potentially a lot of customers, right? So you will be facing potentially a bill doesn't stand in relation to your own value or your own payments for the software, but to the totality of the value of the software. So think about that. It might be completely prohibitive to even pick this bill up.
Yeah. Yeah, and I'm just as an aside, we're going down to 7 where it talks about indemnification, which is a long section, and we've talked about these sections on different videos. I would encourage you guys to look at the playlist for other videos. But, you know, one of the point that seems to be standing out to you is at the very beginning where it talks about who's indemnifying here. Why highlight the word beneficiary? What's standing out to you?
It's just because we get to indemnify the Escrow London together with the depositor for any liabilities whatsoever. And it doesn't make any sense. How is it that I should be liable for anything? I don't own the copyrights in the source code. I didn't create it. How is it exactly that I can sort of impose some liability? You should at least put some fences around which kinds of indemnifications you should be applied to you as a customer, and which should be exclusively applied to the depositor. It doesn't make sense to put everything in one bowl because we're not equal parties. I didn't create the software. I'm just paying the bills and using the software, right?
Right, and the whole point in this kind of agreement is to benefit the beneficiary, which brings us to the last thing we wanted to talk about, which is the force majeure clause down in 10. It seems to undermine the very point in why we're doing this agreement. Talk to me about the force majeure clause in an escrow agreement.
Yeah, it's kind of odd, right? Because one of the functions of an escrow agent is to keep safe this source code and protect it and make it sure that it's available even under adverse circumstances. You know, that adverse circumstance that might take out the software vendor might also take out huge parts of other infrastructure, right? So I can't really, having a force majeure clause whereby the Escrow London can get out of its obligations under this agreement is odd, because they are supposed to protect us, among other things, not only the sort of exclusive events happening to the vendor, but also more general events. So I would at least make sure that such a force majeure clause couldn't be used to escape things like flooding, lack of electricity, whatever, hacker attacks, and so on, that I'm actually actively seeking and paying for the protection against. So force majeure might be okay. Overly broad force majeure clauses like this, absolutely not.
And it's not like this is an insured, sword from Alexander the Great. There's only one copy. You can only have it in one physical place. You can spread this code in different, all this data in multiple places to protect it. And the chances that the whole world's going to be flooded, we've been told that's not going to happen for a while. So I think we'll be okay if you put it in other places. It's an interesting principle there about, the language, because somebody's unfamiliar, undermining the purpose of the contract. So let's get into principles. Tell me about what's the big principle that we can pull from this, even if we're looking beyond a contract of this type.
I would say that if you're looking to software agreements in general, and agreements that have to do with the technical aspects of software, this case being able to recreate and effectively continue to maintain the software, it is not useful to have something like this reviewed by somebody who doesn't understand software, how it's built, because they will not detect half of the issues and the critical issues of this. So for something like this, you really want somebody, ideally with an engineering background, who became a lawyer, or the other way around. Because they are so technical, and it's the smallest thing that can trip you up and make your insurance policy completely uninteresting and unusable. So I think it's one of those types of agreements. There are other types of agreements. If you're licensing source code from somebody to use in your own product, other kinds of things, highly technical things, I would advise against taking the advice on something like this from anybody who doesn't understand themselves how software works.
Yeah, you don't need just any nerd, guys. You need a nerd like Martin. Martin, if people want to follow up with you and talk more about these kinds of IT contracts, I mean, obviously you've dug into these deep, both as a lawyer and now as an owner of a tech company. What's the best way for people to reach out to you?
So I'm on Twitter as Martin Clausen 8, and I have my own company called Syngrato, where I'm reachable on my email, Mike Alpha Charlie, mac@syngrato.com.
Awesome, you guys.
As I say, yeah.
Sorry, go ahead, Martin.
No, I was just going to say I'm happy to talk to people, chat people on this. I don't provide legal advice actively anymore, but I'm still interested, as people can tell, maybe too interested in these things. So I'm happy to chat about it. And if nothing else, point you in the direction of somebody who's just as nerdy as myself, who are actually, still making their living advising on these things.
This is a safe place for nerdiness, Martin. Thank you. I appreciate it. You guys, all the information that we've talked about, including the link to this document, which can be found on Law Insider, will be at lawinsider.com/resources. You can find the contact information for Martin in the show notes as well. And if you want to be a contributor to the Contract Teardown Show, just email us at community@lawinsider.com. I need more friends. Call us. Go to community@lawinsider.com. Email us there. We'll see you guys next time. Thanks again, Martin.
You're welcome.